Hello, my name is Cesar Pereira. I'm a chartered arbitrator and a fellow with the Chartered Institute of Arbitrators, and I'm here representing the C.Arb Brazil branch. It's a great privilege to host here today Professor Ingeborg Schwenzer, Professor Edgardo Muñoz for the second episode of the 2025 webinar on the Vis Moot problem and the issues regarding specifically the substantive part of the problem. As you may know, this is the third time that we have this webinar. It has become already a tradition, actually, and for me, it's an honor and a pleasure to share this initiative with our branch chair, Cristina Mastrobono. And I encourage all of you, as you normally do, to use the Q&A feature on Zoom to submit your questions and take advantage of the opportunity to discuss with Professor Schwenzer and Professor Muñoz these very interesting topics. It's an incredible privilege for us to have both of them here for this webinar. Professor Ingeborg is, I would say, like as everybody knows, the personification of the CISG, Lady CISG. As if you have been to the Vis Moot in Vienna for the past few editions, you know she's also a rock star, a dancer, and a performer, and she is the editor and one of the authors of the commentary of the most important commentary on the CISG. She shares with Professor Edgardo Muñoz the Global Sales Law book, which is, if I'm not mistaken, already in its third edition. And she is a member and a former chair of the CISG Advisory Council. And Professor Edgardo Muñoz, and she, as you all know, also she's Professor Emerita of the University of Basel. Professor Edgardo Muñoz is a professor at the University of Guadalajara. He is the force behind one of the most amazing pre-moot and CISG and international arbitration conferences that take place around the Vis Moot season. It's going to take place next week in Guadalajara. If you haven't registered yet for the online version, please do. I think it's probably still possible. He is the editor responsible for the translation of the CISG into, of the CISG commentary into Spanish, and I think that's already also in its second edition. And so, in Professor Edgardo Muñoz is also a member of the CISG Advisory Council. So we couldn't have better speakers here with us to discuss the issues relating to the Vis Moot problem, especially with regard to the substantive matters. I'm not going to go into an introduction to the problem. I'm sure all of you already know the problem by heart, but I would just like to point out that there are some really interesting substantive issues that are under discussion. We will talk about mixed contracts, about turnkey contracts. We'll talk about internationality of contracts and how that is affected, if it is, by the participation of a local provider or supplier. We will talk about what happens when the buyer is a government, if that is enough to exclude the CISG, if the use of public procurement methods such as reverse auction, electronic reverse auction, is an issue with regard to the CISG. We will talk about whether it makes a difference in the exclusion of the CISG, the fact that the buyer is a government, and in how we should interpret the fact that some contracts or solicitation documents, requests for proposal, requests for quotations, do make a reference to local, national public procurement laws. Is that an exclusion of the CISG? Those are all topics that we are going to discuss, and as you may have already realized from your studies in this field right now, government contracts are an area of growing use of the CISG. And so not only because of the Vis Moot problem, but also because of your legal practice, it will be very interesting for us to delve in more depth into these issues today. So thank you again, Ingeborg and Edgardo, for being here with us. And without taking any more time, I would like to invite Ingeborg to discuss one of the most important topics that we have been all studying in this season, which is how to treat mixed contracts. What do you think is like the state of the art thinking about mixed contracts, especially turnkey contracts? Are we always down to calculating the economic relevance of each portion of the contract, or can we go beyond that?
Thank you very much, Cesar. Thank you for the kind introduction. Ladies and gentlemen, it's an honor and pleasure for me to be with you today at this webinar organized by C.Arb Brazil branch. With regard to Cesar's question, well, you all know the subject matter of mixed contract is regulated in Article 3 of the CISG. I think it's one of the most important provisions of the CISG because the CISG managed to bring mixed contracts under the CISG, and that is a true achievement compared to most domestic law that distinguish especially between contracts for the sale of goods and contract for work and labor on the one hand, and contracts for the sale of goods and contracts for services on the other hand. In domestic legal systems, it is very difficult to draw the line between these three contracts and the consequences, for example, in case of a breach, they are very different. So it is a great achievement of the CISG that it tells us when the CISG applies also to a mixed contract. If you have a look at Article 3, then you can distinguish the two paragraphs. In paragraph 1 of Article 3, you have the delimitation between contracts for the sale of goods on the one hand and contracts for work and labor on the other hand. And the CISG governs such a mixed contracts always, except in cases where the party who orders the goods undertakes to supply a substantial part of the materials necessary for such manufacture or production. This first paragraph is relevant in turnkey contracts because typically in a turnkey contract, the seller does not only undertake to deliver the goods, but it undertakes to design, manufacture, deliver, installation, testing, training of the goods. Thus, the design and manufacture are governed by Article 3, Para 1. That means as the seller does supply the materials necessary for the manufacture or production, this fact does never hinder the CISG to apply. Thus, the mere fact that in a turnkey contract, the seller undertakes to design and manufacture the goods does not hinder the application of the CISG. Now we turn to Article 3, Para 2 of the CISG, which contains a delimitation between a contract for the sale of goods and a contract for services. Article 3, Para 2 tells us that the CISG applies unless the preponderant part of the obligations of the party who furnishes the goods consists in the supply of labor or other services. But it's very important, you have to diligently read Article 3, Para 2. It does not say the CISG applies if the preponderant part of the contract is the sale of goods. No, it is just the other way around. It does not apply, the CISG does not apply if the preponderant part of the contract is the services part. So it must be the services part that is the preponderant part in order to deny the application of the CISG. So in a turnkey contract, the first step is to find that the design and manufacture of a power plant, for example, like we have it in this year's Moot Problem, does not hinder the CISG to apply, because in that case, it is the seller who supplies the materials necessary for manufacture or construction of the plant. And then we turn to Article 3, Para 2. Again, in such a turnkey contract, the seller undertakes, in addition to delivery of the work, it undertakes the installation, usually the testing of the plant, the training of the personnel of the buyer. And then we have to ask, well, does this part, the installation, testing, training, does this part form the preponderant part of the contract? And only if we can find that this part, the services part, forms the preponderant part of the contract, then the CISG does not apply. But usually in a turnkey contract, this will not be the case. So how do we determine whether the services part is the preponderant part of the contract? Well, usually we will ask whether the economic value forms the preponderant part of the contract for the services or not. How can we determine the economic value of the sales part and the services part of a contract? Well, first of all, as in all cases, we turn to the contract itself. And in many international contracts nowadays, you will find that the parties themselves designate that 80% of the purchase price, for example, are the equivalent for the delivery of the goods, whereas 20% pertain to the services part of the goods. Then it's very clear. In other cases, where you don't have such a clear provision in the contract itself, you may have a payment schedule, for example. And then you might find that up to the date of delivery of the goods, already 70 or 80% of the purchase price are due. This is a clear indication that the parties value the delivery part, the sales part of the contract with up to 70 or 80%, so that the services part clearly never amounts to the preponderant part of the contract. If you look into the commentaries, you will find, well, but the economic view should not always be decisive. But if you look into the examples these commentaries give, these examples from the textbooks are not really relevant in practice. Usually there's one example, well, if a party undertakes to paint something with gold, then the gold will have a higher value than the painting job. Well, okay, but when does that happen? So it's certainly not the case in a turnkey contract. There we can clearly rely on the economic values of the parts of the contract, be it the parts of the sale part of the contract or the services part. And to sum up, the mere fact that it is a turnkey contract is in and of itself not decisive. We have always to weigh the respective parts of the contract according to Article 3. And only if the services part is the preponderant part of the contract, if its value is more important than the sales part, and there are also discussions, what is preponderant? Is it 51%? Is it 60%? Or should it even be more, 70%? So this is another question. But usually in a turnkey contract, the services part is not much more than 20%. And then it's clear that the whole contract, the whole turnkey contract, is governed by the CISG.
All right. Thank you. I have two follow-up questions. One is, in theory, you could think that, let's say, if you have a turnkey contract in which the services are 60%, even in that situation, without the 40% that correspond to the physical platform on which those services will be provided, let's say maintenance services or other services that are connected with that physical structure, without that, those services would be meaningless, right? And so but I don't think that would be a valid argument under the CISG, right? To say, even if those services cost more, are more valuable, they would be impossible without the physical delivery of goods. And so the physical delivery of goods is actually what's preponderant in terms of the usefulness of that contract to the buyer. Is that a valid argument? I don't think so.
Well, first of all, the parties could always opt into the CISG, which I clearly would recommend for parties if there is if there are any doubts, what is the preponderant part of the contract. On the other hand, I think that would be difficult to bring such a contract as you explained to us under the CISG. Indeed, where the preponderant part of the contract clearly is the services part, probably most courts would decide that the CISG is not applicable.
And if you come to the conclusion that the preponderant part is services, and so the CISG would not apply as a whole, could you split the contract and apply the CISG only to the goods portion of the contract?
Sure, that would be under the domestic law then, because domestic laws split the contract. They apply the law of services to the services part of the contract and the law of sales to the sales part of the contract. Still, for an international sales contract, it would be the CISG that applies. It just would not apply to the whole contract, including the services.
Okay, thank you. Well, turning to you now, Edgardo. Well, as we all know, one of the issues here in the problem is that the arbitration agreement there and the applicable law provision say that the conflict of law rules do not apply, right? And for that purpose, can the CISG be considered as a conflict of law rules or a set of conflict of law rules?
Thank you, Cesar. First of all, for the invitation and for the privilege of being here with Professor Schwenzer and all your participants. The answer is no. For many of us, is obvious. The CISG is not a set of conflict of law rules. It doesn't look like a set of conflict of law rules, and it doesn't have that purpose. Conflict of law rules look more like the Rome regulations for Europe, where you have indications to the judge about which law applies when there is a foreign element in a contract, or they look more like the Hague Principles on conflict of law, which have the same task to tell the judge, especially in the absence of an agreement, which law would apply to a contract who has international character, right? The judge could not assume that in a contract before him that has a foreign element, he would apply his own substantive law. So that's the role of conflict of law rules, and the CISG does not have that role. The CISG is actually a set of substantive rules on the sales contract, on the international sales contract. You will include their obligations on interpretation, formation, obligations for the parties themselves, remedies, and the consequences of unwinding the contract. And actually, the CISG, with regards to judges, they don't need to consult their own conflict of law rules when deciding on whether to apply the CISG. For judges, as you know, they look at Article 1, and if the requirements of Article 1(1)(a) are met, the CISG applies. The only occasions where a judge may look at his own conflict of law rules, which is not the CISG, is when they apply the CISG because their conflict of law rules lead to the application of a contracting states, which is the solution in Article 1(1)(b). And I think one of the most clear evidence that the CISG is not a conflict of law set is that in Article 7(2), the CISG states that for matters that are not covered by the convention, you need to look at the conflict of law rules of the relevant judge to apply the CISG for all those external lacunas or gaps. And for arbitral tribunals, actually the CISG applies through their conflict of law rules in the lex arbitri. They need to look at either the arbitration rules or as I said, the lex arbitri, and the CISG may apply if they find that is a proper law under those rules, right? But to sum up, I don't think that to be like concrete to what the Moot problem says, I don't think that they were excluding with the reference to conflict of law rules, the CISG, even if they refer to the conflict of law rules of a contracting state. What probably they were trying to do is to avoid international private law phenomenon that is called renvoi. They were trying to avoid selecting Mediterranean law, I think it's in this case. But by choosing Mediterranean law, they didn't want to select also the conflicts of law rules of Mediterranean that could send them to a different country. That's probably the purpose. And I think that confirms that they wanted the substantive law of Mediterranean to apply. And within the substantive law, there is the CISG. The CISG is part of Mediterranean substantive law applicable to international sales transactions. And that's where I would stop my answer, Cesar.
Thank you, Edgardo. Just to play devil's advocate here, when the provision talks about conflict of law rules, it doesn't necessarily mean a specific body of rules like the CISG or a law or something, but it could be maybe certain provisions of a body of law, right? And as we were talking before, when Ingeborg was talking about mixed contracts, in many situations, what the CISG does is point whether a certain matter is governed by the substantive rules of the CISG or by domestic law. And so you, like to say, validity is one of the typical ones, or even what Ingeborg was saying about splitting a contract between contracts, services and goods, and having two different laws apply to that. In that sense, the CISG does offer a solution about what law will apply to certain situations, right? It will say,
I understand.
It
what
will
you
say,
mean.
yeah. So it will say, here you go to the substantive rules of the CISG, or here you go to domestic law.
Yeah.
Can somebody say that in that regard, it would be a conflict of law, or at least it would contain certain conflict of law rules?
Well, in my opinion, the rules in Article 1 to 6 of the CISG set the scope of application of the CISG. They are not conflict of law rules as such. The only one of them that could be argued works like a conflict of law rules is Article 1.1, when it sets the application of the CISG to contracting states, to parties located in contracting states, or through the rules of conflict of laws. But in this case, and that would be an argument, in this case, we are before an arbitral tribunal, and arbitral tribunals are not bound by that provision. They are bound by their own conflict of law rules and their arbitration rules or the lex arbitri. So I think I know what you mean. I understand, but it turns around interpreting also the context, as Article 8 of the CISG says, the context, the circumstances, and it would be a difficult argument to make yours, I think. But I take it. Yeah.
Okay, thank you. Yeah, well, we'll have to give both sides some hope here, right? Okay, now Ingeborg, I was curious here. This case has a lot to do with Article 6 CISG and exclusion, right? And that's one of the main issues. What do you think is different or not when Article 6 implied exclusions or derogations involve domestic public procurement laws?
Well, let's first have a look at the interpretation of Article 6 in commercial contracts without the involvement of a state. So the CISG Advisory Council has published an opinion on the question of exclusion of the CISG under Article 6. And well, the core of this opinion is that the CISG, if the parties want to exclude the CISG under Article 6, this intention must be clearly manifested. When is such an intention clearly manifested? Either if the CISG is explicitly excluded, for example, the parties agree on Swiss law to the exclusion of the CISG, or it may be impliedly excluded, and this may be done by the parties choosing a law of a non-member state of the CISG, like English law, if they choose English law. This is an implied exclusion of the CISG. The mere reference to the domestic law of a member state of the CISG is not enough, is not a clear manifestation of the intent of the parties to exclude the CISG. Why is that so? Because the CISG is part of the domestic law of any member state of the CISG. Thus, if the parties choose Swiss law or Ecuadorian law, this is not in itself an exclusion of the CISG. Rather, there must be something more. Like, for example, if the parties provide in their contract the Swiss law of obligations, the Code of Obligations of Switzerland. This is an implied exclusion of the CISG because the Code of Obligations in Switzerland contains the same set of rules as the CISG does. So there must be something in addition to the reference to domestic law of a member state. And now the question arises, is it enough if in addition to the domestic law, the choice of law clause references a public procurement statute? Well, usually such a public procurement statute will not amount to a complete set of rules on the sale of goods. What do these public procurement statutes contain? Usually they contain rules about the bidding process, especially the protection of equal treatment of all the bidders. But they do not contain rules on, let's say, breach of contract, remedies for breach of contract. Usually they don't contain rules on the duties of the parties under the contract for the sale that is concluded between the bidder and the state or the state entity. So the question is, should we treat procurement contracts, that means contract where a state that is a member state of the CISG or a public entity that is governed by the state of the CISG should be treated differently from a commercial contract? Actually, I think in essence, it should not be treated differently. There are two approaches actually that contradict themselves. One approach is there should be a higher standard for the exclusion of the CISG under Article 6, because the bidder, the foreign bidder, trusts in the state party that they will apply the CISG, as the state party is a member of the CISG and undertook to implement the CISG. So that would be one approach. We have a higher standard. There's another approach, arguing for a lower standard under Article 6, and that is mostly based on the duty of the state in public procurement to treat all bidders equally. And the argument goes, well, in such a bidding process, we do have international bidders from countries that are member states of the CISG, but also maybe from countries that are not members of the CISG. And we may have domestic bidders that are clearly not where, if there is a contract between the state and a domestic bidder, this is clearly not governed by the CISG because it's not an international contract. And thus, these people argue, well, the equal treatment of bidders requires that the domestic law is to govern to the exclusion of the CISG. So again, I think for both sides, there are ample arguments that you can use to support your client's position in that case.
Thank you. There's just a curiosity. In the Brazilian public procurement law, there is a section about international public procurement, international bidding, and in that section there is a provision saying that the same rules should apply to all bidders. They're not thinking about the CISG, obviously, but it would be something express exactly in the direction that you mentioned, that so it would probably be a difficult argument to overcome.
Yeah.
How do you deal with that domestic law provision saying that the rules for everybody have to be the same?
Yes, I think that's one of the crucial discussion points that we have to address, indeed.
Yeah, well, on the other hand, what about that specific point, you could always say that each bidder has its own specific situation with regard to many things. One of them is the applicable law to the contract. But you have, let's say, if you are a corporation, you have a certain level of taxation or whatever. If you are a partnership, you have a different situation. So you choose where to locate your business, and it will be part of your business organization. Right? And so that's not really treating parties differently. It's just treating parties according to their different situations. So it's
that
good
would
thing
be
is that
rather the position of the bidders. The position of the state would be, well, we can compare the different bids only if they are based on the same law. Yeah.
Yeah, that makes a lot of sense, because you have different rights as the buyer, right, under the CISG or not. Yeah. Oh, very good. And Edgardo, keeping with the public procurement topic here, we know that Article 2B CISG excludes the CISG when a sale is made by auction. Now, in this case here, we're talking about reverse auctions. Isn't that exactly what the CISG says that excludes its application?
Well, it's not exactly, because it doesn't say reverse auctions, but yeah, it says only auctions. I think to answer this question, and I think this is one of the most interesting issues that the case talks about. I would approach this first by looking at what the drafters meant when they say auctions, right? One important thing before that is to actually try to understand what Article 2 is. Article 2 is a provisions where the drafters of the convention wanted to make clear that they did not agree that certain type of sales or goods would be covered by the convention. So there was not agreement. And because of that, we have to interpret what they wrote that very narrowly. The starting point is that if they said electricity, for example, they excluded electricity, that doesn't mean that they excluded gas and oil. And it's a common opinion. They are both sources of energy, but the other two are not mentioned. And with the case of auctions, I think the first approach should be the same. And once we know that we have to interpret it narrowly, I think we should look at the history of the provision and what they had in mind. What they have in mind at that time, although historical interpretation doesn't always work for the CISG, or should not, but what they had in mind is the traditional auction, where you would have the buyers who bid a high price, where usually it would be not online, it would be in person. They would sell different objects. And in that case, probably one of the reasons they excluded it, and that we can see from the preparatory works, is that for the buyer, sorry, for the seller, there was no visibility of who was the buyer. If it was a consumer, if it was a business, if he was domestic business, if he was international business. So that seems to have played a role. On the other hand, something that may have played a role, and this is where you may find arguments to say that reverse auctions should also fall in the exception, is that rules on auctions, on traditional auctions, especially on formation of traditional auctions, are different in domestic law. They have specific provisions for auctions regarding how the contract is formed. And also, in many countries, they have different remedies. For example, they have limitation on vis cachet, on hidden defects, and time to claim hidden defects sometimes in some countries. And so from that perspective, we could say also that public reverse auctions have particular rules on contract formation, and that the state, in some cases, retains some prerogatives. For example, to change the contract if circumstances come out, or to modify it, etc., etc. So I think that's the way I would approach the question, but it's not exactly the same. That would be my first conclusion, or my conclusion.
Yeah, and I think it's interesting to put that also in perspective in terms of public procurement. Reverse auctions are basically a method of selecting the supplier, and the conclusion of the contract is there will be the award. There is even a question here about the award, like the recognition that somebody is entitled to the contract, and then the contract will be formed, right? It's quite different from what happens in a traditional auction, in which the auctioneer like bangs the hammer there, and then it's over, and you're bound at that moment.
You don't know who bought it, actually. Yeah. You don't know who, and in as you are right, in public procurement, it's just usually the auction is the first stage, and then you have the competitors with the lower prices, and then you assign it, taking different considerations, but you know if it is abroad, the seller is abroad or not. Yes, that's correct.
Yeah, I will take a moment here to address two questions that we received. One is, I think we can direct this one to Edgardo. Arielle Garcia asked, is there a difference between excluding the conflict of laws rules or provisions versus conflict of laws principle? Because the language in the case, in the Moot problem, is excluding conflict of laws principle. And so she's asking, is there a difference, or is it all the same thing? And just for Ingeborg to think about this, Luisa Longari asked, in the case, it said that public procurement law covers only the bidding process and the award. In this sense, how could a team argue that the domestic law must also be applied to performance or termination of the agreement to the detriment of the CISG? So if the parties only mentioned application to the bidding process and the award, would that be enough? So Edgardo, would you like to go first?
I think first we need to figure out what the parties meant by principles, and we need to look at the negotiations and everything. But if a reasonable person would just watch at the word, it may come out with the conclusion that they refer probably to the Hague Principles on conflict of laws, and the Hague Principles are not even hard law. They do not apply unless the parties chose them, agree on their application. So the clause actually is It's not clear. It's weird. But I think that at the end of the day, there is no difference by saying the principles of conflict of laws with regards of whether the CISG has been excluded.
Yeah, what I was thinking when I saw the question here is that maybe you could argue that by using principles rather than rules or provisions, the parties wanted to be broader, and maybe they maybe that would help that argument that I was trying to make. You know, that you can you can find some like something there hanging that's not so clear as a body of laws, but it could still be something that the parties wanted to avoid. But of course, it will always be, as you said before, a matter of interpretation of what the parties intended to do, and if just to address Ariely here specifically, if you can give some meaning to why principles is different, what did the parties want by using that word specifically? Maybe that would be something that you can build on. But Ingeborg, so would you like to address the issue of the scope of the public procurement law in this case?
Yes, as I mentioned before, as we decided in the CISG Advisory Council, the mere mentioning of domestic law is not enough to exclude the CISG under Article 6. Rather, the intent of the parties must be manifested that they wanted to exchange the set of rules contained in the CISG by another set of rules, like by the law of a civil code of the country or the like. So I think it's going to make it difficult to argue in a case where the public procurement statute only contains rules for the bidding process and the award, that it was the intention of the parties to put this set of rules instead of the set of rules contained in the CISG. So for respondent for the state here, other arguments must be found, especially that the participation of a state and the necessity of treating all bidders equally amounts to an implied exclusion to the intent of the state to exclude the CISG, and that this intent by the state was recognizable for the bidder. Because under Article 8, the question whether the parties have validly excluded the CISG under Article 6 has to be judged in the light of Article 8, the interpretation of the contract, the interpretation of the conduct between the parties. And we all know under Article 8 in para 1, primarily, it is the intent of a party that is decisive. But if the parties have different meanings of a conduct or of a contract clause, like here, of the choice of law clause in the contract, then we have to go to Article 8, para 2, and we have to ask, what would a reasonable person in the shoes of the contracting parties have understood by a certain term? And then we have to ask, would a reasonable bidder have understood this choice of law clause that is usually a boilerplate clause provided by the state, which is not negotiable. Actually, we have to see that in public procurement, most of the clauses of the contract are not negotiable between the parties. They are drafted by the state, and they are given to the parties at a take it or leave it Yeah. So it's not up to the parties to negotiate on different terms, but they have to take the contract as given by the state. So, and then the question is, must a reasonable bidder expect this choice of law clause provided by the state to exclude the CISG? Yes or no? And that is question of interpretation. And again, you may find arguments for both sides.
Yeah, it's interesting what you said about negotiation, because this case, the problem mentions negotiation phase. And that's very common in public procurement to have negotiation phases. But it's true that negotiation generally does not allow a very broad discussion of the terms of the contract. It's basically a price negotiation, sometimes a time of delivery negotiation, or but a very limited type of negotiation. Right? There is a question here that has a little to do with that. Maybe you could address that, Ingeborg. Fong Vu Te asked, is the analysis of party intent in negotiation sufficient in implicitly excluding the CISG? And he asks, is the criteria for implicitly excluding the CISG by party intent fixed or flexible? Could you address that?
I think it's always flexible, because I have to ask, what would a reasonable party in the shoes of this party understand by a certain clause? So that is flexible, because it has the word reasonableness in Article 8, Para 2. So I think it's well, and the state, I have been involved actually in rather a few investment cases where the CISG was potentially applying, where we had a state on the one side and an investor on the other side, but it was a commercial arbitration. It was not an investment arbitration, because these contracts that are entered into always have a commercial arbitration clause, despite you might have a BIT, a bilateral investment treaty between the country of the investor and the state concerned. But then you have parallel, you might have a parallel arbitration as a commercial arbitration. So, and in many of these cases where I was involved, actually one has been published, it's very akin to the case that is the problem for this year. And it's an arbitral award that has been published. It was between a Russian investor and the state, or a public entity of the state of Ecuador. And it was also about a hydropower plant, and again in that case also the state argued that they excluded the CISG. And I have had many cases actually, in true investment cases, but as commercial arbitrations, where the state argued that the CISG does not apply. And that is why actually the CISG Advisory Council is right now preparing an opinion with the help of Dr. Cesar Pereira. He's the rapporteur on this question on public procurement and the CISG. So you cannot already read our opinion, but we have almost finished it, and it's going to be published in 1 year or 1.5 years, and then you might be enlightened what concerns this case.
Yeah, we'll probably have a lot of more material to discuss after all this after all this exercise with the Vis Moot problem this year. And I'd like to ask you 2 more questions before we address the many questions that we are receiving here at the Q&A. I'll just go back, Edgardo, to you. It has something to do with what Ingeborg was saying about like taking into consideration all the circumstances in all this flexibility of the CISG in taking into consideration the reality of the situation in which this contract exists. In international public procurement, it's relatively common for governments to require local content or what's called offset obligations, obligations in which in exchange for selling to a government, you undertake to engage local companies to help to transfer technology, things like that have to do with local benefits of that contract, right? Now, my question is the participation of local suppliers for reasons of local content, facilitation sometimes of local payments, or these offset obligations, is that a feature that can amount to a trade usage under Article 9 CISG? And then, if so, how does that affect the idea of internationality? How should internationality be understood in that context?
Yes, I think this is very interesting on your proposal of looking at Article 9 or Article 8.3 and have a look at usages and practices to address this concern. But I think that before doing that, we should look at the concept of internationality in the CISG. In the CISG applies, as you know, if there are parties located in two different states. I take back a bit what I said. If you have parties with places of business in different contracting states, or actually even if they are not contracting states, in states, right? So this is a criteria in the CISG for internationality. Two contracting parties located in different states. And so for the CISG, it doesn't matter if, for example, the seller engages someone to comply obligations on his behalf. And this happens all the time, right? He could hire a supplier from any country, including the country of the buyer, to, on his behalf, for example, deliver certain components, or he could outsource as well himself components from different countries, including the buyer's countries. This is for the CISG something taken for granted that doesn't affect the internationality of the contract. And also the contract can be performed in the buyer's country by the seller itself or the buyer. It doesn't affect that this is an international contract for the CISG. Now, what may be different is where there is a company that is engaged in the negotiations, together with a local company which is linked with the seller and participates during the negotiations in the conclusion of the contract. Because in that respect, you have, for the seller, two relevant places of businesses. But if during the negotiations up to the conclusion of the contract is the seller itself who negotiates, who enters into the contract, the relevance of two places of business becomes, or in other words, is irrelevant, because the circumstances of the internationality should be assessed at the time of the conclusion of the contract. Well, but now let's say that you have two companies of the seller taking part in the negotiations. One of them makes a contract, signs a contract, but still the other one has a relevant role. In that case, we need to look at Article 10. And Article 10 is a provision that tells us which of the two companies of the seller is the ones who will fix or will have something to say about the internationality. If the relevant place of business is the company of the seller, which is located in the same country as the buyer, then you may lose the internationality in this case. But if it is often the case, and this is where usages have a role, if it is as often the case that the local company, I mean, a company established by the seller in the buyer's territory, it's only there because it was a requirement. But all the transaction, all the indications about performance, all the negotiations came from, for example, the parent company that fully controlled the local company. I think that the parent company will be the relevant place of business for the purpose of Article 10. Probably I wasn't that clear, but it's because it touches different. It depends on the specific case, as in the case file here, and as the moot problem. But to sum up, the place of performance, or whether the seller outsources or outsources materials, or some local company performs on his behalf, is usually irrelevant. It's only when there is a different legal entity which becomes the relevant place of business in the buyer's country under Article 8 that we may have problems with the internationality, and where usages can tell us that the place is or not the relevant place of business under Article 10.
I think it's interesting, Edgardo, that in private international law, there is a lot of discussion about fraud, right? Like frauds, leges, and the idea that you, let's say, you manipulate the facts and you manipulate your behavior in order to, let's say, to make something look like it's international and that a certain law will apply, but in reality it isn't, right? And so here you might have this situation in which actually, let's say, local companies want for some reason to be under the CISG, and they use a foreign office to participate in the contract to make it look like it's international. But I think the beauty of the CISG in Article 10A is that you don't have to go that far. You simply identify what the relevant or place of business is, and you will come in this example to the conclusion that the relevant place of business was in the buyer's country, and therefore there was no international contract, right? And so I don't know, Ingeborg, do you agree? Are you were doing something like this?
I think Article 10 helps us a lot. I mean, in these cases that I know, I mean, also many companies, many investors are required by public procurement laws to set up joint ventures with an individual from the state. And I think Article 10 helps us a lot by defining what is the place of business with the closest relationship. We must have regard to the circumstances known to or contemplated by the parties at any time before or at the conclusion of the contract. So it's clear for the state that this subsidiary or joint venture is only built for the purpose of this bidding. Yeah, and it's clear that the investor has its place of business, its place of business with the closest relationship in the country of the parent company. So I think this again helps us to define which one is the place of business with the closest relationship to the contract.
Good. Now I have a question about what you were saying when you mentioned joint venture. Is there an issue in terms of who controls the joint venture? For instance, until 2021, the Brazilian public procurement law provided that in a joint venture between a foreign and a local supplier, the local supplier needed to be the leading party in the joint venture. And so in a situation like that, would that mean that no contract would ever be international because the leading party would always have to be local, and therefore that would mean that the state wanted that contract to be local and not international?
I think we have to distinguish. I mean, if the contract is only between the state and this local joint venture, then it's a domestic contract. Then no international partner is involved in it. But that is usually not the case. Usually the case is that you have both as contracting partners, the parent company in the foreign state and the joint venture in the same state as the state buyer. So, and in that case, we have to decide according to Article 10, which is the closest, which place of business has the closest connection. And there, I wouldn't say it doesn't matter whether the domestic party controls the joint venture or whether the foreign party controls it.
Okay, thank you. Well, we have 21 questions. We'll see how many we're going to be able to ask. I had a question to you, Ingeborg, about Article 2C CISG. If you can, like in 10 seconds, just give give the audience your opinion. I understand it's a relatively simple point, right?
It's a rather easy answer to this question. Article 2C excludes sales on execution or otherwise by authority of law. And I think it's very clear that this exclusion concerns execution of judgments, bankruptcy proceedings, or any authority based on regulations of executions, but clearly not government contract. What supports this position are the French and the Spanish versions of the CISG, the Spanish version and the French version. They talk about judicial sales, which is much clearer than the English versions, sale by authority of law. So they are talking of judicial sales. And then we have the problem that we face in many instances. We have the 6 authoritative versions of the CISG in the 6 UN languages, which encompasses English, French, Spanish, Chinese, Arabic, and Russian. I almost forgot Russian. Okay, so how can we use the French and the Spanish version to clarify what the English version doesn't really clearly spell out? Authority of law is not as clear as judicial sale. That is clearly much narrower than a sale by authority of law. And I think if we have 2 versions, French and Spanish, that talk about judicial sales, this can be clearly be regarded as the true intent of the drafters of the CISGs. Thus, the English version may be interpreted in light of the French and the Spanish versions. I don't speak Arabic or Chinese, so I cannot tell you what the other versions of the the CISG tell us, but you might consult them. You can use any machine translation, and you will see what the other versions of the CISG tell us, and then you might argue either side again.
Yeah, no, I think it's interesting about this issue of the different versions, that it's true that the negotiations were mostly in English, but French was also a diplomatic language at that time. It was like in the 1970s. And so I think it's very important that the French version also has or confirms what the Spanish version says, and maybe the others as well. Yeah, thank you. Well, so we'll try to address in the 18 minutes that we have left as many questions as we can. João Lucas Liberato, well, you may follow Ingeborg and Edgardo if you want to take a look at the Q&A here. You may follow the questions here. João Lucas Liberato asked a question about this. In a scenario where parties rely on provisions of non-harmonized law during the formation of an international contract for the sales of goods, would that be sufficient for an implied exclusion of the CISG, or an implied waiver of the right to apply the CISG, negotiating based on not on the CISG during the formation of the contract? Anybody?
Probably as an arbitrator, I would decide against it. But again, you students are not arbitrators in that case. You are counsel. And so you have to argue each side, yeah? You have to argue that it's possible that by relying on rules on contract formation, this would be an implied exclusion of the CISG, or you may argue for claimant in that case that this is a simple derogation under Article 6 for the rules on contract formation, which can be derogated from, but that the rest of the rules, especially the obligations of the parties, breach of contract, and remedies in breach of contract are not excluded. So,
well, just a quick follow-up here. How do you see, both of you, how do you see those boilerplate provisions in contracts? Because here I assume what João Lucas was saying was the parties exchanged letters mentioning domestic, like the civil code or something, some domestic law of obligations while they were forming the contract. And maybe there are provisions there about the entire agreement, disregard of previous communications, and all those boilerplate clauses. Well, how much weight do you give to a boilerplate clause like that in a context in which the CISG requires us to take into consideration all the circumstances and all that? How important are boilerplate clauses?
Edgardo, do you want to go forward, please?
Well, they are part of the materials you need to consider, even if they are, standard clauses or not. This is I think it looks fair to consider them as part of the materials. Now, whether they may be part of the agreement or influence the understanding of the parties on later clauses that were fixed in the contract, or whether they incorporate any practice, that will depend. Really, is a specific case by case. A tendency would be to say, well, boilerplate clauses, parties just repeat them and they do not have any idea why. Probably they know what they mean, but they don't know why they are repeating them, right? I have a colleague who works in one of the big tobacco companies. He was a muti like me, and he asked, "Why are you always excluding the CISG in these cases?" And nobody he was now the top of the in-house top of all of them, and nobody could explain this. It's because it comes from the past contract, right? But when they are there, I mean, you need to consider them sometimes as part of the agreement, sometimes as just that, as a habit with no meaning.
Oh, thank you. And Ingeborg, there's a question that I think would be for you here. Somebody, it's not identified here, asked what happens if there are options, like here in this case, there are options that can be exercised later in the contract and change the balance between services and goods. How do you consider that?
That's a very interesting question, and I think the problem is really good regarding this point. Well, there are two possibilities. Either I say these options overshadow the main contract, and we have to look at the whole agreement, including the options. Or we may argue, well, these options are irrelevant. We do not know whether they will be exercised and what will happen. We just look at the original contract. So again, I think there are ample arguments for both sides.
In Edgardo, going back to the issue of conflict of laws rules, Milan Markovic is commenting here that there's literature to the effect that Article 11A is considered to be an incomplete or unilateral conflict of laws rule. You mentioned something about that. So is that sufficient for that article at least to be considered as excluded by the governing law clause in this contract?
Yeah, it seems like, I mean, I have a tendency for claiming here, but indeed, I mean, Article 1 is considered a conflict of law rules, and mainly because authors are saying the CISG has his own conflict of law rule. You don't have to look at the other conflict of law rules, right? Is the scope of application is there in the first articles, and that looks like a conflict of law rules you don't need to look at. But only for judges, for arbitrators, not. But still, I don't think that that would be enough to exclude the conflict of law rules of a country and then automatically exclude the CISG as a whole because you are excluding Article 1 of the CISG. I mean, even if we interpret that article is a conflict of law rules, that would be difficult, especially in arbitration.
Yeah, and that there is actually a question about that here. Hanin Joma asked if arbitrators always rely on Article 11A of the CISG to determine its applicability. So going to your point, how is the CISG applied by arbitral tribunals? Do they have to rely on 11A, or is there anything else that arbitral tribunals take into consideration?
Well, in practice, you see many case law arbitral awards that arbitrators rely on Article 11 to apply the CISG, interestingly. But a starting point for arbitrators shouldn't be that provision, in my opinion. You see many commentators that state that that's only for judges. The starting point for arbitrators is the lex arbitri, and then the arbitration rules, or the arbitration rules and the lex arbitri. You want to comment on this, Ingo, because you've written on this, yeah.
Yeah, I mean, the starting point for arbitrators is always the intent of the parties. Yeah, what did the parties want? Which law in all in all arbitration laws and rules that I know, the primary focus is on the party's intent, on the party's will. And if they explicitly choose a law, if, for example, if they opt into the CISG, the arbitrators will apply the CISG no matter whether the CISG itself wants to be applied. Like, for example, if the parties to a services contract choose the CISG to apply to this contract, then the arbitrators will apply the CISG, no matter that Article 3 would not lead to an application of the CISG. If the parties are not explicit in their choice of law, then we have to again ask, well, what is the implication of this choice of law clause? And then very often we come to the conclusion, well, the same as a state court would do, that the reference to a domestic law is not enough in itself not to apply the CISG, because the CISG is part of the domestic law. And if the parties did not have a choice of law clause, then as an arbitrator, there are different possibilities. There are some, like the model law refers us back to rules of private international law, but in most other arbitration laws or arbitration rules, where the arbitrators will choose the law that is most closely connected to the contract by the parties. And this law will, in most cases of an international sales contract, be the CISG. That is the most closely connected law in an international sale. So the starting point always is the intent of the parties, and that is whereby arbitrators are bound, not by any domestic law or by any private international law rules of even not of the seat of the arbitration. They are not bound by them.
You were going to say something, Edgardo?
No, that some arbitration rules and laws actually also say that the arbitrator has the discretion to choose the most appropriate law, not even the closest connected, the most appropriate law.
Yep.
And CISG is the most appropriate for sales, it happens to be.
Yeah, so that means an arbitrator could apply the CISG even when looking at Article 1, it would not apply to that contract, maybe as Lex Mercatoria or something like that.
Yeah.
We have a question here from Wendell Mello, and he's saying that if the public procurement law governed the tender process, how could we set apart the reverse auction in the purchase and sale agreement, since the law does govern the performance and termination of a contract, but on the other hand, the CISG was not the law applicable during the formation of the agreement. So basically, let's say, can we have different laws for the formation of the agreement and for the other obligations in performance, termination, and the other aspects of the agreement?
Yeah, I think so, yes. Well, yeah, I think we can look this from two different angles. We can say that there is a partial derogation under Article 6. That means that the parties impliedly agreed that that part of the rules of the CISG on formation would be derogated in favor of the rules of formation of the bidding process. Or you can also look at it from the mandatory law perspective as being mandatory. That would be practically the same effect probably on certain provisions of the CISG that touch upon the validity of the contract.
So in that case, there is actually a question here about, it's from Laura Raquel Silveira. She says, does the tribunal has discretion to apply overriding mandatory rules? In the case, we have a provision in the Civil Code of Equatoriana stating that government entities can terminate contracts for matters of convenience. And then she asks, you don't have to address specifically that, but if you can, of course, if you want. Is that a mandatory rule? And if so, how does that affect the case? If you would like to address that more generally, Edgardo and Ingeborg, mandatory rules in the CISG.
Well, in my country, there we have something similar, and yes, that would be a mandatory rule, but the consequences may still be governed by the applicable law. That means the state may decide to terminate, and there is no remedy of a specific performance. You cannot bound the state to not terminate and continue with the relationship, but the consequences of the termination, that means damages, may still be governed by the substantive law applicable. In this case would be the CISG. I don't know, Ingeborg.
Yeah, usually it is said that arbitrators apply mandatory provisions that are part of the international public policy. And probably such a rule in a civil code, in a domestic civil code, even if it is mandatory, would not be regarded as being part of international public policy. These are usually rules on corruption and things like that have found their way into international treatises, but certainly not a mandatory rule of a civil code. I wouldn't think that an arbitral tribunal would apply this rule.
Mm-hmm. Milan Markovic has another question here, and the topic is about place of business, and the question is, can the term place of business be considered as an external gap under the CISG, as there is no definition of what place of business means? In that case, what domestic legislation, if any, could point to the tribunal to determine what is place of business under the CISG? Would that be possible? Think about some definition of place of business that would come from outside the CISG.
No, I don't think it's an external gap. You can find I think you can have a definition in Article 10 as well. I mean, obviously the Article 10 is the function is to distinguish between the relevant place of business, but also tells you some clues about what is a place of business. Is a place where the seller is acting that has a relationship, not the closest, but a relationship with the contract, right? Which has to do probably with it says with performance probably, et cetera. But I think it's an internal probably gap, but not an external. You don't need to go out of the CISG to define it.
Yeah, I entirely agree with Edgardo. All the provisions of the CISG must be interpreted autonomously out of the CISG, because otherwise we would have different definitions of place of business according to the otherwise applicable domestic law, which would be unsupportable under the CISG and which would undermine its uniformity, actually.
Well, thank you. And on that note, we have reached precisely the end of our time here. And I'd like to thank again Professor Ingeborg Schwenzer, Professor Edgardo Muñoz, and thank the Chartered Institute of Arbitrators Brazil branch, especially its chairperson, Cristina Mastrobono, for the opportunity of being here with all of you. As you know, this webinar has been recorded and it will be available. You feel free to share that with your colleagues. Again, if you haven't registered yet for Professor Edgardo Muñoz's excellent conference next week, please do. And I hope to see many of you in person in Hong Kong or Vienna during the competitions. Thank you and see you next time. Bye-bye.
Thank you, Cesar.
Thank you very much. And bye-bye, everybody. And good luck at the competition.